Disney is trying to have a man's wrongful death lawsuit thrown out. Get this, because it's a little unbelievable, all because he signed up for the company's Disney Plus streaming service years earlier. Let me give you the backstory here. So Jeffrey Piccolo suing Disney after his wife died last year. According to his suit, she suffered a severe allergic reaction after eating at Raglan Road Irish Pub, a restaurant at Disney Springs. The lawsuit says it happened despite warning the restaurant about severe dairy and nut allergies, and the restaurant acknowledged it multiple times, they claim. But court records show that Disney wants the suit dropped because Piccolo signed up for a 1-month trial of Disney Plus in 2019. I'm not kidding. Disney is basically saying the terms of service for their streaming service mandate that users settle any lawsuits out of court through arbitration, and they waive their right to a jury trial. Disney says Piccolo agreed to similar terms when he bought a park ticket on Disney's website last year as well. In a legal filing to those claims, Piccolo's lawyer said Disney is, quote, explicitly seeking to bar its 150 million Disney Plus subscribers from ever prosecuting a wrongful death case against it in front of a jury. Even if the case facts have nothing to do with Disney Plus, the same can be said of the conflicting Disney terms of use and My Disney Experience agreements.
Well, that's a lot. So we have a lot of questions about this, and we're sure that you do too. So we brought in attorney and managing partner at TK Law, Raymond Trendley. Thank you so much for coming in.
Thanks so much for having me.
Let's just begin with the obvious. Walk us through exactly what Disney is saying here, because it seems like to me they're saying anyone with a Disney Plus subscription has given up or signed away their ability to ever sue the company for anything.
And it's not just Disney. What is so absurd about this position is that it's not just Disney, it's the affiliates as well. So anybody that Disney owns an interest in or is in a contractual partnership with could possibly be exempt for any liability for personal injury, gross negligence, and even death, assuming Disney's successful in raising this argument.
Wow, I did not know that part of this. Okay, so here's my question. Disney's argument is basically, hey, I'm sorry your wife died, but you signed up for our streaming service. Could an argument like that possibly hold up in court?
So the answer is, anytime you throw a Hail Mary, there's always a possibility for a touchdown. I don't think Disney's going to be successful in this case. It's a hyper-technical argument, and generally speaking, we want people to be free to engage in contracts, but they have to be clear and unambiguous. And who signs and reads the 200-page liability waiver when you sign up for Disney Plus on a temporary, free month of subscription? It's just not reasonable.
Yeah,
do we all have something at stake here? Because when I sign up for a new service for anything, I go right to the end, agree. You assume that you're not giving up your firstborn and your left arm.
And you know, it's so funny you say that, Ginger, because that was exactly my thought. You could be selling your soul potentially by signing a liability waiver, by clicking that box. And I think that Disney has a real problem with the proof element, because they have to prove that the person who was injured at Raglan Road, that they actually signed that waiver. And I think that the facts are that allegedly it was the husband who signed it. So the husband wouldn't necessarily have the ability to waive those contractual rights for his wife, who's unfortunately the victim. And so I think they have a problem with proof as well, because, I mean, even my kids can go on and sign a subscription up.
They have a problem with proof, and they have a problem with the way this looks to
what a story.
The entire country.
Thank you for breaking that down.
We appreciate it. You did a great job breaking that down, Ray. Thank you so much.